Is your business protected against the threat of malicious litigation and frivolous lawsuits? Are you sinking company profits into marketing campaigns that do nothing to contribute to the growth of your business? Bottled Business Sense provides practical business perspectives that uniquely emphasize both legal and media marketing strategies to protect and ensure the longevity of your business. And whether you're trying to provide a startup business with some level of stability or an established business with foolproof asset and estate protection, or simply attempting to get a better return for your business marketing dollars, Bill Bernard and Rick Moscoso will expose potential pitfalls to ensure the security and growth of your business, free from unwanted expense and the threat of litigation. You'll learn how to implement marketing and protection tools equal to those used by today's most successful corporations. Let's join Bill and Rick for today's Bottled Business Sense show.
Well, good morning, everyone. This is the Bottled Business Sense show. I am Rick Moscoso, one of your co-hosts here this morning. I want to welcome all of our returning viewers and listeners to the show, as well as our new viewers and listeners. Today is Tuesday here at 10 a.m., and we have an exciting episode here today with my co-host, Bill Bernard, who's on the other side. But before we get into that, again, welcome, everyone. You can always take a look at previous episodes that we've done in the past, and we tailor this show to the business owner and offer free advice, free best practices in regards to how to protect your business legally and make sure that you're protected properly, as well as marketing and video marketing tips and just general topics in regards to your business, how to run it efficiently so you can do what you set out to do, and that is to be profitable and to have fun with whatever it is that you have a passion of doing. So with that, want to bring on to the screen Mr. Bill Bernard, who is several thousand miles away this morning. It's kind of early, but thanks for joining, and I'll just bring on Mr. Bill Bernard. How are you doing today, Bill?
Well, I'm doing fantastic. Taking a little vacation and taping a couple shows here so we can make sure our audience is up to date on what we're doing and continuing to take advantage of this free advice. Remember that some of the things we talk about, especially with regard to legal issues, are not particular to your situation. Specifically, it is basic general information that you should adapt when necessary to whatever situation you may find yourself in by conversing and consulting with a lawyer of your choice to make sure that you are implementing these legal principles correctly. So you need to have your own lawyer on board, your own marketing person, your own tax person, so you can go to them and use our topics as a heads up, so to speak, or a red flag as to something that might be happening that you need to have taken care of. But remember that what we talk about in terms of legal perspectives here on this show, as the disclaimer at the end of the show always says, is not specific to a particular business owner. So in the event, I thought what we talk about today, questions on this, Rick, is pre-business litigation prerequisites. And what I mean by that is, so oftentimes we'll get complaints from clients, customers, even employees, and they'll come after us or come at us with some problem that sometimes are legitimate and sometimes not legitimate. But as I've said many times in the past, you don't have to be in the right to be sued. People can take advantage of the court system and bring a lawsuit, and with that comes a lot of business expenses, and many times even frivolous claims are brought in the hopes that the lawsuit will settle and somebody will get some money out of it, whether the claims are legitimate or not. Having said that, I thought I'd develop this show into a little bit of a talk as to what you might want to do to reach out and try to fend off a situation before it gets to the courthouse steps. And there's several ways to do that, and I thought maybe our business owners would be enlightened a little bit on how to do this. And sometimes it can even be done without the full-blown retention of a lawyer if you do one specific thing. Excuse me. And that is remove the emotion, if you can, from your decision-making process. I mean, that's why you hire lawyers to begin with, because they can be objective. The problem doesn't involve them specifically. Present yourself in these sort of situations. You're pissed off. Mm-hmm. And so it inhibits your ability to think clearly. And so you have to make that judgment. Are you that kind of an even-keeled person to make a bid, or do you want to fight them head on, or do you maybe want to take a third option and hire a lawyer to maybe help you nip it in the bud before it gets to the courthouse steps? That's really what this should.
And a lot of times it's hard for a business owner, isn't it? I mean, you're so connected, you're so close to the problem that sometimes you lose sight of objectivity and you let your emotions, take over and end up making a decision based on your emotions, which may or may not be the right one.
No, many times, many times. People let emotion get in the way. I'll give you just a quick little story about. This has nothing to do with litigation, but how easy your emotions can be fired upon. Heard a guy talking to his wife the other day, a neighbor of mine, and they're having a conversation about how the wife took the car in to get fixed and didn't get the right information, and this person was getting ripped off, right? And so the husband's ticked off that the wife may be getting ripped off, and he gets emotional because he feels somebody's taking advantage of the wife, and because of the tone of his voice, takes it out on the wife, right? Because he's upset, and he's saying, why didn't you do this? Why didn't you do that? Well, it's really not upset at the wife per se. He's upset at the car person, right? The car repair person. But he's not thinking clearly because his emotions are interfering with his ability to be rational. So now you take a business who's got this problem, right? And somebody's threatening to sue you. Well, now that's a little more serious. So you can imagine how ticked off somebody can get. And my point here is whether you can do it on your own or whether you need to hire a lawyer, you can still participate in pre-litigation prerequisites, as I call them, to attempt to fend off a lawsuit. Here's one thing you can do. Before any litigation is filed, place a phone call. Call the person directly, or if you know they have a representative, a lawyer who's already involved, call the lawyer and say, look, what's this all about? What do you want? What is it that we can do to rectify this situation? Here's my position. Make sure you have the position drawn out, written down in a logical fashion, and follow some bullet points. Don't just talk off the cuff. Write down bullet points and address those bullet points in a logical fashion, in a sequence that makes sense, and say, here's what I understand the problem to be from your client. Here's what I understand are the issues that I have. Perhaps we can reach some sort of a compromise. Now, off the cuff, this may not seem like some great magical piece of advice, but how many people attempt to do this? A lot of people don't because they're just too upset. So you got to put that aside. And if you can't put that aside, get a lawyer involved and pay the lawyer to make the phone call for you. Because many times these people will start reach out to them and address this before they even retain an attorney themselves. That's critical. So that's one thing you could do. If it reaches the point where a lawyer becomes involved, and now you're not going to be able to compromise by way of a phone call or by way of written correspondence, please offer some attempt at independent mediation, where a third party can sit down with you and maybe mediate the issues and give the person some idea on each side as to where their prospective positions might be and where they're coming from. Sometimes you can do this informally from the standpoint of just having it be non-binding, that is just for the person each party getting advice from the mediator, or sometimes you can even make it binding and sign an agreement and say, okay, whatever this mediator says is what we're going to adhere to. And we each pay our own costs, because the mediator will charge a fee. We each pay our own attorney's fees if we have our own attorney, because each attorney is going to charge to appear at the mediation and prepare for it. Or you just appear at the mediation independently without any lawyers and just pay the mediator himself or herself.
So
how
Bill,
many people think of
Bill, take us through the scenario where two parties would want to include a mediator with their attorneys, or just a mediator?
Well, that's going to depend probably on how far they've gotten prior to the suggestion. If you dilly-dally around, or you don't take any seriousness in the claim that the other person is making, you're probably just going to linger until eventually this person hires a lawyer. If that person hires a lawyer and the lawyer's involved, then it may be more difficult to get to mediation until you get your own lawyer and they're able to talk. On the other hand, if you address it and try to nip it in the bud and go directly to the person before the lawyer's involved, you may be able to convince that person that a mediation would be, quote, unquote, less expensive. And that's really the key. Why would you want to get a lawyer involved to where you're going to be paying more money if you can reach an agreement with the other party to go to mediation and save a little money, understanding that you're going to have to pay the mediator, but you won't have any attorney's fees, at least up until that point. So, whether you have a lawyer involved or not affects it from the standpoint of you being able to talk to the person directly, because once the person's represented, you really shouldn't speak to them directly. And once the person's represented, now you're talking about a lot more expense. So what's the incentive to go to mediation maybe with another party before a lawyer's involved? Well, very simply, the business expense that's going to be incurred if you start getting lawyers and involved and eventually if you have litigation. So another option would be arbitration. Arbitration is similar to mediation, except arbitration a lot of times presents a more full-blown evidentiary presentation. Many times briefs are done. Many times evidence is put into play. Not to say that can't happen at a mediation, but an arbitration is formal, more like conducted more like a courtroom setting in most instances, and sometimes maybe even a little more expensive because it's going to go on for maybe a lengthier period of time. Might go on all day, might go on for a couple days or maybe a week, who knows. Typically an arbitration is more difficult to get involved in until a lawyer is involved on each side. However, the bottom line is you're attempting to avoid court ahead of time, right? Where it's really going to get expensive because now you're going to be paying an attorney on a long-term basis, not only for discovery to take place, but up until and through the time of trial. Remember, interestingly enough, you can go to a mediation or arbitration to try to nip the problem in the bud before you conduct discovery. However, once a court appoints you to mediation, in other words, a lawsuit may be filed and then the court may say, hey, you guys need to go to mediation, you guys need to go to arbitration. Well, then the attorneys for each side are going to say, yeah, but we want to do discovery first. We want to do interrogatories, requests to produce documents, depositions. That's all going to cost money. If you do the mediation prior to getting involved in litigation, it may be that you're able to do it less expensively without going through the entire discovery process that litigation naturally entails. So what's the bottom line there? You save a heck of a lot of money.
Yeah. Typically, where does arbitration take place? Is that at some neutral place, or does it take care of it in court? Or?
No, well, if it's appointed after you file litigation, the court, then you're going to have to decide where it's going to go. You're going to have to pick a mediator. But even before litigation, if you decide to go to mediation or arbitration before any lawsuit's filed, if you attempt to reconcile this independently with each other, you will typically pick a mediator from a number of different organizations that exist within your county where retired judges and lawyers serve as mediators. You pay a fee. It could be anywhere from maybe, I'm just throwing this out there now, $1,500 a day for half a day to $3,000 or $4,000 for a full day. Now, that may sound like a lot of money, but many of these contractual issues or employee issues that you have that are thrown into the mix at you can be done in a shorter period of time with an independent, objective third party. Now, do you want to pay anywhere between $1,500 to $4,000 a day, or do you want to go on and have thousands of dollars in litigation fees by having a lawsuit filed? That's sometimes not always your choice, Rick, but you can do everything to make it your choice, is my point in the show. You can reach out and try to resolve things, and even if you can't, and you have to end up in litigation, at least you've tried. Remember the old motto, you cannot get what you don't ask for. So if you don't reach out to somebody and at least try, they may tell you to go stick it. But you're never going to know that until you ask, right?
Right.
So do you want to pay a lot of money? Do you want to expend a lot of money in litigation that you might not ordinarily if you take the opportunity to reach out and try to explore these issues? Something else that you need to know, if you have an employee issue and you have an HR department, which you should, a human resources department, and that employee comes to you at human resources with a complaint, try to rectify that complaint before the employee files a formal complaint with the Equal Opportunity Employment Commission, which is federal, or the Fair Employment and Housing Administration, which is California-based. Once those complaints are filed, those agencies get involved. They do an investigation, and that typically leads to a lawsuit. So you have to make sure you have a good employee handbook, you have a good HR department that follows that employee handbook, nip these problems in the bud. If a problem should arise and squeak through the cracks, or as I like to call it, the gun show loophole, right? If you can squeak through there, then you better be prepared with a good HR department to try to address these issues. Follow the rules that are addressed in your employee handbook, which are far too many to address in this show today, but we've done other shows on employee handbooks. You have to make sure you know what the law is and you follow the law, and if you can, you may be able to address these issues. Because here's what happens. Any two people who are mad at each other, what happens, Rick? You get defensive, right? Mm-hmm. And when you get defensive, you what? Emotional. And when you get emotional, you get what? You don't think clearly. And when you don't think clearly, many times the problem is exacerbated to the point where I'll see you in court, buddy, right?
Yeah, right.
So that's why you need a good lawyer, and I go back to why I named my business Legal Consulting. Consult with a lawyer. Maybe you don't have to retain a lawyer full blown. The lawyer, you can consult with your lawyer who's on board for your company that you've had from day one. You go and you ask him a question. You place a phone call. You have a meeting with him. You may have a nominal charge. You may not. But the point is, depending on your relationship with this lawyer, he or she is going to tell you what he or she thinks you should do. If the lawyer is worth his or her salt, they're going to tell you what to do before you have to resort to litigation and a lot of money in their pocket. Remember, if you've got a good lawyer, that lawyer's obligation is going to be to save you money, not just give you the bang for the buck that they would give you if they have to actually represent you full-blown in court. That to me is the mark of a good attorney. Hey, here's how I think you might be able to save money, Rick. Here's what I suggest you do. I'll monitor this situation for you. I may charge you a nominal charge. I may not, depending on the length of our relationship and how much business you've given me in the past. Who knows? There's a lot of factors there. The point is, I'll be there and I'll have your back. Let's try to avoid court. And then if I do have to get involved, we can still try to avoid court, only I'll take the reins over and direct some attempt at mediation or arbitration. And then, of course, along the way, if we go to court, I'll be there and I'll back you up full, all the way. That's the way it should typically progress. So I hope people have thought about this by way of some common sense and attempt to reach out and communicate. Because remember, without communication, you're going to have a lot of heartache because there's going to be a tug of war on both sides. So you have to have an open mind and be able to meet in the middle if you can, and you have to have an open mind and understand that perhaps whether you're in the right or not, a business decision would be more economical for you in this instance than going down the road full blown and fighting it out in court.
Yeah, I think you just hit the nail on the head right there. I mean, it's, everyone wants to win. They don't want to lose. But at the same time, you're trying to protect your business. And sometimes, losing to save the thing that you're trying to preserve may be the right direction. And it's going to take an attorney to seize the playing field from a perspective that you as a business owner is too close to see and can't see it. So somebody like Bill can take that big perspective and take a look. And he's the quarterback. He's the coach. He's the quarterback. He's the guy seeing the whole play field, right?
That's right. That's exactly right. He's the quarterback. And that's how this word, Rick, developed years ago, counselor at law. You hear the word lawyer, you hear the word counselor, you hear the word attorney. A true counselor at law, I believe, counsels his or her clients as to the application of law in their particular situation. It doesn't necessarily mean a lawsuit has to occur. It means that if you have an attorney that you've consulted with and retained from the day one of the opening of your business, if you have a tax accountant that you work with from day one, if you have a marketing person you work with from day one, your business will be so much stronger and more solidified than it would be if you have to go out and get one of those three people when a problem arises instead of planning to make sure no problem arises. I mean, it's really that basic. Mm-hmm. So anyway, I that's what I would urge. I hope this has been somewhat helpful to our viewers and listeners, and kind of makes them think about the real world and say, hey, let me put this emotionalism aside. Let me put the reason I'm ticked off aside, and let me see if I can be reasonable with this other person. Because if I can't, then I'll do what I got to do. But you don't know if you can't until you try, right?
That's right. Well, this is great advice, Bill. This is great food for thought. If you're ever in this situation, which I hope we don't have to experience, but there are instances where it just happens. It's just a fact of life.
Yep.
And if you do run into this situation or know but someone that runs into this situation, please reach out to Bill. His contact information is below this video. But he's always available via phone. And what's the best way to get a hold of you, Bill?
Both 949 area codes. You can reach me at my office at 698-6222, and my direct line is 413-6535. That's my website and email, bill@wfconsulting.com. So happy to help if I can. And remember, this show, when we started it, Rick, was addressed, was implemented to address, I should say, the protection of your business and the prosperity of your business. The idea being that if your business is protected in the manner it should be, you'll have less and less opportunity to be exposed to litigation. But that doesn't mean that if you are potentially exposed to it, you can't use common sense and try to reason things out as opposed to reacting emotionally and saying, okay, see you in court, buddy. So, it's a conglomerate of things that you do. You're a business. You're not just a person who is a professional in whatever business you're in. You're a business person as well. You're a business owner. And that entails thinking a little bit differently than you might when you just apply your skill set to a particular job that you're doing. You have to step outside the box, and you have to think a little bit differently, independently.
Well, that's great advice, and we appreciate your insight into situations like this. It's you certainly don't want to go through the heartache of doing this on your own. as difficult as it may be. So a consultant like Bill is a trusted consultant like Bill is certainly somebody that you want in your corner. So with that, thanks, Bill, for the information. Thanks for laying everything out like that, and really appreciate it. Hope everyone found that of value. That is our show for today, and be sure to be back next week at 10 a.m. next Tuesday for the next episode of the Bottle Business Sense Show. I am Rick Moscoso, and on the other side is Bill Bernard. Have a great day, Bill, and we'll talk to everyone again real soon.
You too. Take care, everybody, and have a prosperous week. Bye-bye now.